Have you ever read a rule and just thought to yourself, I know what that says, but that can't possibly be what it means? That tension right there is exactly what we're diving into today. It's this classic legal showdown between the letter of the law and the spirit of the law. And it's a fight that happens everywhere, from the highest courts in the land all the way down to, a simple parking spot. So let's jump right into a scenario. Picture this. A woman, 9 months pregnant, pulls into a mall parking lot. There's a city ordinance that says senior citizens and persons with disabilities get free parking. Now, she thinks she should qualify, but the mall, they disagree. And this one little conflict puts a huge legal question to the test. Who's actually right here?
And just like that, you've got a standoff. On one side, you have the woman. She's arguing for the spirit of the law. To her, the purpose is obvious, right? It's to help people who have a tough time getting around, and that definitely includes her. But the mall management, they're pointing right back at the letter of the law. For them, it's black and white. If your name's not on the list, you don't get in.
And here are the exact words at the center of it all. The ordinance names two groups, and only two groups: senior citizens and persons with disability. Now pay close attention to how specific that is. There's no wiggle room, and others who might need it. The language is incredibly precise, and that's not an accident.
You see, this whole parking dispute is really a proxy war for a much, much bigger battle between two core legal ideas. It really forces us to ask a fundamental question. How are we supposed to read the rules that govern our lives? Should we take them literally, or should we focus on what they were trying to achieve? So the mall is going with the letter of the law, a very strict word-for-word reading of the text. If you aren't explicitly named, you are not included. Simple. The woman, on the other hand, is arguing for the spirit of the law. She's focused on the goal, the whole point of the rule, which is to help those in need. So when these two ideas crash into each other, how does a court possibly decide who wins?
Well, judges don't just guess. They have a specific toolkit they use for situations exactly like this, tools designed to interpret laws in a consistent way. So let's first look at the tools that really back up the mall's argument, the ones that demand we stick to the exact words on the page.
Okay, the most powerful tool in the box has a fancy Latin name: Expressio Unius Est Exclusio Alterius. I know, it sounds complicated, but the idea behind it is actually super simple. When you specifically mention one thing, you are intentionally excluding everything else. If lawmakers take the time to list certain items, the courts assume they left everything else out on purpose.
Here, think of it like a grocery list. If your list just says apples and bananas, you're not going to come home with oranges, are you? Of course not. Why? Because the very act of listing apples and bananas implies that oranges were deliberately left off. Courts work with the same assumption, that lawmakers are just as deliberate when they write our laws.
And building right on top of that is a related principle, Casus Omissus. This basically doubles down on the first idea. It says that anything left out of a law has to be treated as an intentional omission. In other words, it's not a court's job to fix a law by adding things they think the legislature just forgot. They can't fill in the blanks.
And this is absolutely critical for our parking case. Senior citizen and PWD aren't just vague descriptions. They are precise legal terms defined by national laws. A senior citizen is someone 60 or older. A person with a disability has a long-term impairment. Pregnancy, as difficult as it is legally considered a temporary condition. It just doesn't fit the legal definition. So by using these very specific legal terms, the law intentionally drew a line. And listen, this isn't just some dusty legal theory. Courts use this logic all the time. There's a really important case from the Philippine Supreme Court, Quinto versus Comelec, that shows you exactly how this plays out in the real world. So in that case, there was a law that said appointive officials, people who are appointed to their jobs, were automatically considered resigned if they ran for office. The big question was, did that rule also apply to elective officials, people who are voted in? The court said absolutely not. By specifically naming one group, the law made a deliberate choice to exclude the other. It's a perfect parallel to our parking ordinance. Okay, so the argument for a literal word-for-word reading seems pretty airtight, but it can also feel deeply unfair, right? So is the law just stuck when the written words lead to a result that feels wrong? Let's flip the coin and explore the other side of this. And yeah, it really can feel unfair. Isn't the whole point of having laws to achieve some kind of justice? So can a judge ever decide to ignore the literal text when it leads to a bad outcome? The answer is yes. But, and this is a huge but, only in very, very rare circumstances. A judge can really only bend the rules under a few very strict conditions. First, to stop a result that is so absurd or ridiculous that nobody could have possibly intended it. Second, to fix an obvious mistake, like a typo in the law. And third, to protect a higher constitutional right. This is a power that judges use with extreme caution.
So, does our parking situation clear this incredibly high bar? Probably not. While we all sympathize with her, excluding pregnant women isn't considered legally absurd. A court would likely say that the city council drew a clear, easy-to-manage line for a reason. Expanding it to include a temporary condition, like pregnancy, could open up a whole can of worms that the law was written to avoid.
Okay, so after weighing the predictable letter of the law against the more flexible spirit, how would a court most likely rule in this parking spot standoff?
Given all the legal principles we've talked about, a court would almost certainly rule against the pregnant woman. The law's specific list means that, by legal definition, she is excluded.
And the reason why all boils down to a core principle of how our government works, the separation of powers. You see, a judge's job is to interpret the law as it was written, not to rewrite it into what they think it should be. Adding new groups to that list isn't judging, that's making a new law, and that's a job for someone else.
But a no from a court is not a dead end. Not at all. It just means that the fight for change needs to happen in a different arena.
So if the courts can't fix what feels like a broken law, then who can? Well, the answer isn't a judge. It's a lawmaker. The right fix here isn't a judicial one. It's a political one. It's about actually changing the law itself.
The path forward is actually pretty clear. The power to write and change laws belongs to the legislative branch, in this case, the city council. The real solution is to lobby those council members, to make the case for change, and to convince them to amend the ordinance to explicitly add pregnant women to the list. That is exactly how our system is designed to work and evolve.
And that leaves us right back with that fundamental question. While the law gives us a clear answer in this case, the philosophical debate never really ends. When it comes down to it, where should a judge's ultimate duty lie? Is it to the exact words printed on the page, or is it to a broader, more universal sense of justice? It's a question that gets to the very heart of how we choose to govern ourselves.